You just found out someone broke their contract with you. What kind of damages will the court award? Spoiler alert, probably less than you think. Hi, I'm Michael Dorff, and I'm the Executive Director of the Lowell Milken Institute for Business Law and Policy here at UCLA School of Law. And in the next 2 minutes, I'm going to tell you about the 4 types of contract remedies that courts sometimes award. They'll only award one, though, so it's important to understand what your options are. The most common type of contract remedy awarded by courts for breach of contract is called expectation damages. The purpose of expectation damages is to put the injured party back in the position they would have been in had the contract actually been performed. So for example, you entered into a contract to buy a car for $9,000. The seller breached and you had to go find a similar car, but it actually ended up costing you $10,000. What are your expectation damages? They're not the full $9,000 or $10,000, it's just the $1,000 difference between what you were promised, a car for $9,000, and what you got, a car for $10,000. The second type of contract damages is called reliance damages. This is money spent, usually in preparation for performance, in reliance on the existence of the contract. So, for example, you're a contractor. Homeowner hires you to redo their kitchen. You spent a bunch of money on materials, let's say $1,000 on materials in preparation to perform, and then they breach without justification. Under reliance theory, you're entitled to get that $1,000 back, the money you spent on materials getting ready for performance. Third type of damages is called restitution damages. The idea of restitution damages is to prevent unjust enrichment, money that the breaching party got that they don't deserve to keep. So imagine that this time you're hiring a contractor and you paid them $500 up front earnest money. Then they walked away without ever doing any bit of work. You're entitled under restitution to get that $500 back. It's unjust for them to keep that money since they didn't do any work. The fourth type of contract remedy is called specific performance. That's when the court orders the breaching party to do exactly what they promised to do in the contract. That seems really intuitive, like it should be the normal form of contract remedy, but actually it's rare. Courts consider that an extraordinary remedy, and the circumstances under which they do that are fairly complicated. So we're going to do a special video just on specific performance later in the series. So in sum, even if you are the victim of a breach of contract, you may not get all the remedies you expect. Even expectation damages, which is probably the broadest form, does not include things like attorney's fees, emotional distress, punitive damages, and there are some other limitations as well. Have you ever had someone breach a contract with you? If so, what did you think you deserved? Comment below and follow for contract law that actually makes sense.